And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay. All right, counsels, I've had an opportunity to consider your arguments as well as take a look at Gates 298 Georgia at 324, as well as Garner versus the state at 342 Georgia Appeals 824. Both of them stand for the same proposition about effect on listeners. So I'm going to permit that to be the inquiry area of 60325 to 60. Hold on, get back. Hold on. (60325) through 60605. All right. I'll give you a continuing objection, defense counsels, with respect to that. Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20. And I believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says he's concerned they will put the discovery on IGS, or Instagram.
Yes.
Okay. Can you give me the page references, madam?
Yes, Your Honor. So page 173, line 7, through page 174, line 2.
Okay. All right. Mr. Sharp?
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child. We get into this, it's almost bolstering. It is bolstering, where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen. It has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals that are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals. And it's likely to confuse the issues. It's unfair prejudice towards our clients where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403, 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/19/40.
You know my name? In that car that's gonna put them there. Like you worried about the wrong thing. I'm worried about when you get locked up and you get his skirt back in the seat, I circle each picture and put my name on them. He's gonna send it out to the screen and be like, I done told on him. And they're gonna put it on Instagram and Twitter and they're gonna tell everybody. And then guess what? They're gonna start like, then I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. Either you gonna do it, Woody, or you not.
And Your Honor, that's the conclusion at 6/19/44. And Miss we started at 6/19/06. And Your Honor, may I respond?
Yes, ma'am. What's the state's response to Mr. Chardon and the defense attorney saying that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows not that he's fearful that anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them. And this is a prime example of that. So for those two reasons, we believe that this portion should come in. Additionally, Your Honor, when Mr. Starr says this had nothing to do with this case, that is not true. What Mr. Copeland is talking about in this interview is a retaliatory shooting that occurred as a result of Donovan Thomas being murdered. So again, putting this all in context, Mr. Thomas was shot and killed on January 10th. Over the course of about 6 to 8 weeks, there are multiple shootings. We went over that yesterday, Your Honor. And one of the final shootings was on February 19th, when these group of individuals that were associated with IF gang shot at him, his child, and his baby. And they're trying to get him to identify who one of those individuals were. So it does have something to do with this case. It has something to do with the overall retaliatory shootings that occurred as a result of Mr. Thomas being murdered. And again, in this section, he talks specific about having to come to court. Like, that was his concern here. Like, I have to come to court and I'm going to have to testify about this. He was concerned about doing that. And Your Honor, we believe that that is also why he's changing his testimony in court today. Court during this trial.
Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey? Mr. Steele?
Nothing.
Okay, all right. All right, in considering both sides' arguments in regards to defense 401 being relevance, 403 being unduly prejudicial, or and the state's assertion that is impeachment by contradiction, the court does find it is relevant for the that even using 403 as a balancing test, it is more probative than prejudicial and shows impeachment by contradiction. So I'm going to allow it over defense objection, and I'll give you a continuing objection in regards to that. All defense counsel. All right, let's cover number 9. Number 9 is 626:30 through 627:05. And as you framed it, Gaither gives speech about the need to put an end to the shootings. All right, sir, go ahead.
I was gonna.
You want to play it?
Yeah, can we just play it and then?
Yes. And Your Honor, it's page 181, lines 8 through 12. I'm going to start a little earlier at 6:26:22.
I can't deal with this shit, man. And I understand that, but you gotta help you right now. We trying to get a stop to all this back and forth shooting.
You trying to back and forth shooting? Gee, they only shoot.
Well, shooting at you.
Shit.
We trying to get a stop to this. And we pulling every resource in the city that we can, but we can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do, but you gotta fucking, I'm doing what I gotta do, man. Help me out. I'm doing it.
Damn, man. Why I gotta go through this, man?
Go to, I don't know, but I'm into it. Bruh, I'm ready to get started on the aftermath. I'm ready to get started on that. I can't work towards homicide. I'm picking up the pieces of the aftermath for the homicide. Here.
Your Honor, we stopped at 6:27:30.
So, Your Honor,
All right, sir.
my objection, again, these statements are allegedly prior statements. I mean, the reason we're playing for the jury over our objection, to defense objection, is because they're prior statements by Mr. Copeland. We have the non-declarant, Investigator Gaither, just talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be a neutral. And that's the impression that the jury is given when they're exposed to, again, this speech. I call it a speech, but whatever you want to call it, by Investigator Gaither, where she presents this as, look, it's, the city and all the authorities and the police department, we're all working to try to put an end to these shootings, and it's you guys and Mr. Copeland, it's your information that will put an end to it, and it's your group that's involved in all this. I believe it's inappropriate. I believe that it invites the jurors to consider it invites them to take into consideration factors that should not be considered in that jury room. And it's essentially an improper argument. If it was made during closing, we would argue that it's an improper argument. And just because it's not a closing argument doesn't make it not improper. It's improper for the jurors to hear that type of talk by Investigator Gaither, especially considering the whole reason that this tape is being played over our objection is not for Investigator Gaither's words, but for Mr. Copeland's.
All right. Ms. Hilton.
Again, you have to look at this in totality, Your Honor. This starts off with Mr. Copeland saying, why do I have to go through this man? And Gaither is then going into, I need you to do this. I need you to identify who it is so that I can get started on my investigation, so I can continue my investigation, I can continue my work. So while Mr. Sharp calls it a speech,
Hold on, y'all. A&F feed was cut. I'm coming. Hold on, I'm gonna get the feedback. Hold on.
This bag is a game changer. Say hello to the
It does. I agree with Mr. Steele. It doesn't really add anything to it, and it's for the reasons he mentioned. Okay.
okay, so line 8 to 12, we can.
Yes. Anybody else have any other comment or any other argument in regards to number 9, 626.30 or thereabouts is 627.30? All right. I'm gonna. Other than that particular admission, omission, or exclusion from that'd be page 181, using state's transcript, lines 8 through 12. The rest is can be played.
Thank you.
Okay.
Yes.
All right. And I'll again admit an over objection and give a continuing objection. Does the defendant still maintain that none of this is proper and they should not be played? So, okay. All right. Number 10. And number 10 is 6:30:30 through 6:31:50. And you are saying that that's 404A evidence about Mr. Stillwell and inappropriate comments about character.
Yeah, 404A and B.
404A and B. Okay. All right, sir. Oh,
I
I'm sorry, Ms. Hill.
you want me to, you want to play it first?
Yes, please.
Okay, all right, let's play it. What transcript pages, madam?
The relevant portion will be page 185, line 17, through page 186, line 19. And we'll start 6:30.
6:30 what?
I guess she wasn't looking at it serious like how it is. I really wasn't. I really thought they wasn't. I didn't think they would do it. I didn't think they knew to try to shoot me. I'm pretty I thought really would try to do a kill. They showed me wrong. Well, I know they him for shit. He been on Twitter going back and forth with Shannon. Yeah. What the hell? I'm telling Shannon, why the hell you ugly? You can go on Twitter. What Shannon been up to? Because I know he ain't just gonna sit and let it ride like you getting shot at and all that. I know that. And you know what I told Shannon? Man, let Polly deal with him. No man, he'll pay him. You know what Shannon told me that night? The night they shot me in bed. You know, they like, I was crying. And you know, they like, man, bro, hell nah, bro. We take anything you can. I'm like, bro, fuck this shit, bro. Let them have it, bro. Let them have it, bro. They kill me, bro. You know what's going on, bro. Just hit. Started with Lieutenant Shannon. Police involved with it. They started with it, bro. We ain't going to jail, so we ain't do, bro. You're not going to tell you one of these folks think we did this shit, bro. And that's what I told him. He like, she looked at it. She like, bro, I'm telling you, bro, if they kill you or they hurt you or the baby, bro, they gotta kill him too. Just like him, bro. They don't get your shell out of it, bro. We already in the battle phase. We with people we never thought we'd be with, bro. Fuck that shit, bro. Let them have it. That's why I really ain't getting in there. If I didn't, I feel like.
And stop at 6:31. Voice trims on. So sorry, stop at 6:31:51.
All right, Mr. Sharp.
So this testimony or this out-of-court statement by Mr. Copeland about my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland in as payback for either the January 28th shooting of Mr. Copeland in the car, or shooting at Mr. Copeland in the car, or the February, I guess it would be 19th shooting of Mr. Copeland, or shooting at Mr. Copeland outside of his house, other than, of course, Mr. Copeland shooting back at those individuals and hitting them in their car. My point being, Mr. Copeland is essentially saying that Shannon has encouraged him to, and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence that Mr. Stillwell is someone that when something's done to him or one of his friends, he's going to seek retribution from the other side. And again, if the state had a overact, and I'm making this up, that happened on March 3rd of 2015, where they allegedly saw the car that was shooting at them on January 28th, then I would say, okay, maybe that has some relevance to this specific act. But there's no act that's charged. And what the state wants, essentially the logical conclusion based on hearing that is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
All right, sir.
Yeah, we won't play it.
Okay. I'm going to use Mr. Adams' favorite saying. Easiest decision I'll make today. All right. Anybody else have any other comment about subpart 10, 630, 30 through 631, 50? It's going to be omitted. Anyone? All right. Okay. We've gotten through the flaggings of Mr. Sharp. Does anybody else have any other time periods they wish for me to discuss with the court? Mr. All right, thank you, Mr. Steele. Mr. Harvey? Ms. D. Williams? Mr. Matthews?
No, Your Honor.
Mr. Weinstein?
No, Your Honor.
Okay.
When I say
No, it's with reference to my continued objection for severance and instructions with regard to all of this evidence. I don't want that to be deemed to be a waiver on the record.
Okay, Mr. Harvey, in no way, I'll note it again for you that you have moved for severance and for 105 instruction, which the court is going to give you continuing objection on, but I'm going to deny that this time again, okay? All right, sir. Okay. All right, councils, let's talk a little bit about way ahead in scheduling. I believe that you all have, as well as it pertains to Mr. Copeland, June the 10th interview, which is the longest one. It's 9 hours. Is that correct? All right. Have you all been working on, or I'm going to ask the state first and then defense counsels in terms of what you've identified as to what you're going to play and what you wish to omit?
Your Honor, we sent to defense counsel, I believe on Monday, the areas in which the state, I'm sorry, let me stand up. The areas in which the state intends to redact. Yesterday evening, Mr. Shard, I think, sent me a portion of the areas that they would like redacted. We haven't had the opportunity to look at those. And then I believe Mr. Adams is supposed to send me the secondary portion of that. And so we'll be looking through that over the course of today and this weekend to determine what, if any, areas we can agree to. Once we finish talking about June, Your Honor, I will briefly just want to get some clarity on February 21st, but after we finish the June discussion.
What do you mean you want clarity on the
So we submitted
21st?
We submitted some redactions for February 21st. And I don't know if, kind of along the same lines of the conversation yesterday, if there are areas that the defendants wanted in that the state intended to redact. And if there are those same line of area, we understand the court's ruling from yesterday, but we just wanted clarity because we don't know. And it could be an offline conversation I can have with Mr. Shard to see what their position is.
I think I can answer this. After speaking with other attorneys involved in the defense of other individuals, I believe that there is an objection to the redactions of the timestamps identified by the state. We understand that the state, in their presentation of the case, they may choose not to present some of these excerpts when they play the tape.
Which tape were we referring to?
February 21st, 2015.
All right.
But I believe that the defense is going to seek to admit portions that the state is not going to seek to admit.
And certainly we can have a similar discussion that we had yesterday, or I can authorize, unless there's been a specific objection, I'm going to say you can play it during cross-examination. Like similar to what I did yesterday.
Yes.
Okay. And that's fine, Your Honor. We'll object at the appropriate time.
Yeah, if appropriate, yeah, I'll rule upon it. But I'm most of the things that, unless there's clear argument to the contrary, will be fair game on cross. Okay.
Thank you, Your Honor.
Okay, so let's talk about the June 10th interview. So is it possible for you all to, like, consistent with, this has been very helpful for you all to identify the time periods and for us to work down through them and have discussion one way or another? Are you all in a position to potentially put something together by Monday, and so we can kind of go through the June 10th interview?
The good news is we're all operating off the same transcript for June 10th, and there is a transcript. I believe the transcript's about 550 pages. I made it through 380, and I've identified the specific spots that I object to, and I believe that other attorneys involved in this case adopt my arguments for those first 380. Mr. Adams is diligently working. He's identified the rest, and he is going to send that information over to the state at some point. I don't want to speak for him, but I know he's been working on it. So I think that the state has given us their proposed redactions, correct?
Correct, Your Honor, but I think we're going to be in the same position. So we really need their redactions, because I think the state is, we're going to redact what we're going to redact, and if they choose to want to play certain portions, we can object at the appropriate time. So I think we really need to know what their redactions are in order for us to have a meaningful hearing, hopefully on Monday.
So right now they have about 2/3.
Okay.
Just by the transcript length, about 2/3 of the redactions, and then Mr. Adams is going to get them the rest.
Mr. Adams, will you be finished by Monday?
Oh, absolutely. They'll have them by, I can give it to them by Saturday.
Okay. All right. Okay.
That works.
All right. So we'll work on, now, as it pertains to, since we'll probably take the most of the day with that, I'm inclined not to call in our juries for Monday.
And Your Honor, I'm going to remind the court that we also have the jail phone calls.
Yes, and there's 11 of those at 2.5 hours. All right, and then, counsel, as you all recall, Tuesday the 25th, we'll probably just work from about 9:30 to about probably shortly thereafter lunch. So my inclination as well, I don't think we're going to probably finish with our, it's possible that even if we, that we'll spend or exhaust most of Monday the 24th and Tuesday the 25th getting through the 10th and or 10th of June, as well as the jail calls, and we may not even be finished with those. So I'm inclined to just tell our jurors, have a nice week, unless somebody has something to the contrary.
Nothing from the state, Your Honor.
Anybody? Okay. I mean, I just don't think we'll be in a position for them to hear anything at that point. All right. Which leads me to July 1, 2, and 3. More than likely, we'll probably use, if we don't finish up our business with the jail calls, we'll probably take that up on Monday the 1st of July. Tuesday, we'll probably do the in-camera review of Mr. Copeland's ex parte matter. And I will give you all more pinpoint instructions on that particular time and date. But it more than likely will be the 2nd or the 3rd of July. So that's our kind of work schedule at this point in time to clear those issues before we call back our jurors.
So at this time, we're thinking no jury for the week of the going to the 4th.
Probably not, is what I'm thinking. And I may tell them that so they can adjust they can govern themselves accordingly. But we have a fair amount of stuff to take care of. So, all right. Anything else, councils, at this point in time? If not, I'll see you all on Monday the 24th, 8:30 for anticipated 9:00 start time. We'll queue up the June 10th, 2015 interview and see where that leads us. Okay? All right, anybody else? Okay, all right. We're in recess until Monday the 24th at 8:30.
Kissed by ocean air, darkened by pounding waves, caramelized by equatorial heat. See what the ocean has in store for you. Jefferson's Ocean.
Well, the feed was cut, so I guess that's it for today. I'll be back soon. Y'all be blessed. I'll chop it up with y'all in a few minutes. All right, one. They cut the feed, so I guess that's it for today. I'll be back to chop it up with y'all soon. All right, peace.
Swimming in you. Hey, little mama said I wanna take her. Dipping your pool. Just go for a little dive there. Hey, yeah, yeah, yeah. Sometimes a misty rain that gently touches my soul. Feels just like fire shut up in me. Yeah. Simply lose control.